everyone, welcome to my channel. Before watching this video, don't forget to like, comment, and subscribe. Now let's start this video. Characteristic of United States Maritime Law, Part 2. As to contracts, the test of jurisdiction is the maritime character of the contract and not the place where it is made or performed. Here again, we find some curious fiction such as the holding that a mortgage of a ship is not a maritime transaction but only a banker's business on land. This troublesome rule, which the Commit Maritime Reform by its Lines and Mortgage Convention of 1926, was partly reformed in 1920 by the Preferred Ship Mortgage Act as to United States flag vessel. Shipbuilding contracts are held not maritime but terrene, and a ship launched but not yet complete is not yet a vessel within the admiralty jurisdiction. Against this rule there has been a good deal of protest. A newly launched hull being shifted across a harbor can be in a collision. One may wonder whether a ship that splits into is one ship, two ships, or not a ship at all. We do not distinguish between the oceans, the coast, the great sound and bays, the great lakes, and the numerous rivers, all alike waters to which our admiralty jurisdiction and our maritime law apply, that is in the United States, to trade fluvial such as is familiar in Europe. And indeed, this responds to a practical fact for ocean steamers as can our rivers to very great distances in everyday navigation, whereas none of Europe's rivers are navigated by ocean vessels for more than a few miles from the sea, as to Rouen on the Seine, Antwerp and Rotterdam on the branch of Rhine and Meuse Delta, Bremerhaven and Hamburg on the Weser and Elbe deltas. Consequently, Europe has a river law very different from its maritime law. But in the United States, there is one single maritime law and jurisdiction wherever there is navigable water. An admiralty court might divide damage and fault equally, but not in proportion of fault as is generally done in the maritime law of other countries. This drastic rule has often been debated, and opinion concerning it seems to be equally divided like the rule itself. The ancient rule that death is the composer of strife, in the sense that damage are not given for negligence harm resulting in death, has been entirely abrogated by a series of statutes, but after 100 years, the ancient rule is still perceivably regarded as fundamental. A maritime line, the use in rem, secret, in code, and unrecorded, may be enforced at any time against the ship in rem, unless there is such delay and trust in the circumstance as to permit the equitable defense of leases. This flexible rule has been found to be adaptable to many different situations. The United States rule as to the liability of carriers by sea to shippers, as found in statutory form in the Charter and Carriage of Goods by Sea Act, is essentially the same as the Hague Rules or Brussels Convention on Ocean Bills of Lading. On the other hand, the United States law is as to limitation of an ownership liability does not resemble that of any other maritime nation. Some of its characteristics are discussed at another point in this article. This rapid review will warn the reader that it is unsafe to suppose that maritime law of the United States, just like that of Europe or South America, or even closely like that of Britain and Canada, although the historic and customary foundation of modern European and American law are, in a broad sense, the same. The United States Admiralty practice, the maritime line, and the right in rem, jus in rem are closely identified and exist together. The right in rem is only available to enforce a maritime line and only against the identical ship, cargo, or freight money concern. The details of this practice are quite different from those now prevailing in England or in the British Commonwealth. In the United States, a right in rem may be asserted against a ship without any regard for the presence or absence of the owner or agent. The ship will be arrested in rem by the marshal of the federal court, or even if the ship owner is standing at the spot and offering to give an appearance in the lawsuit. An arrest of this character can only be released by paying the sum demanded or by furnishing adequate security as a pledge to pay whatever the court shall decree to be payable. The security may not exceed twice the amount fairly claimed to be payable. The excess sum is available for legal costs and for legal interest at 6% in most courts and 7% on the Pacific coast from the date when the lawsuit is commenced, or in some cases from the date when the debt arose. The right in rem is necessarily limited to the value of the rest. If a person with a good claim for $10,000 brings a suit in rem against a ship which has a value of only $8,000, the security and the decree cannot exceed $8,000. A right in personam is not so limited in amount and may be enforced against the debtor's future property as well as against his present property. Ordinarily, there is no time limit for asserting any secret maritime lien except leases. A few time limits have been imposed by treaty or by statutes: 2 years for salvage and 3 and 4 deaths and the high seas, 1 year for bills of lading. In deciding what is reasonable time, the courts will look at the time limitation statutes of the states in which they sit for analogies. The ranking of liens when questions of priorities between competing lien claimants arise is in a somewhat confused state. As a general rule, the last lien in point of time outranks prior liens, the exact reverse of the common law rule on the theory either that the most recent service to the ship has preserved it as an asset, for the benefit of prior lien claimants, or that one in whose favor a lien has attached to a ship has thereby acquired an interest in the ship subject to liens subsequently arising. However, certain classes of lien, or such as seamen's wages and salvage, are accorded priority over others regarded as of lesser dignity, so that the ranking depends somewhat upon custom. Also, the statutory preferred ship mortgage is given priority over liens arising subsequent in the time to its recording and an endorsement, except as to liens for wages, salvage, general average, and tort claims, this bringing in the common law rule of priority to the one first in time to this extent. Liens for necessaries and supplies furnished in the home port were formerly not recognized, but this rule was changed in statute in 1910. For seagoing ships, liens are usually grouped by the voyage in the larger harbors. They are ranked by 40-day periods, and in various inland waters they are grouped by the season or by the year. Okay everyone, that's all this article today. Thank you so much for watching this video. Until the next one, bye bye.